Ladies and gentlemen, welcome back to the Indie Zone. My name is Kathy. Back on August 4th, 2025, the better part of 2 weeks after this case was closed, Judge Stephen J. Hippler rendered an order and directed both sides to provide objections or non-objections to the approximate 2.5 months of more than 2.5 years worth of information that has been sealed from the public in Idaho versus Kohberger. Both sides were given 14 days. Both sides went right up to the deadline, filed their responses on August 18th, 2025. And if you read those responses, you will see what the objections and non-objections are that the state has, that the defense has, to the potential unsealing of documents. Earliest possible documents are dated June 2nd, 2025. The most recent are dated July 24th, 2025. Anything prior to June 2nd, 2025, information withheld from the public that is under seal in this case hasn't even been brought forward for the court's consideration. There was also a court order that was rendered by Judge Stephen J. Hippler regarding these responses. It gives the parties an additional 14 days to provide further specific details relative to witnesses that they are contending, and both have, need to be redacted from the public. On a related matter, I wanted to bring to your attention one issue that appears in the responses from both the state and the defense. This has to do with the unsealing of one of the hearings amongst many that were held behind closed doors in this case. It specifically is the June 18th, 2025 court minutes relative to the closed sealed hearing concerning the defense's motion regarding alternate perpetrators. This hearing happened approximately 2.5 months ago. As you see here, the defense has absolutely no objection to these court minutes being unsealed to the public. The state, however, has a partial objection. And you can read it by going to page number 5. And it states here, June 18th, 2025, court minutes for sealed session regarding motion concerning alternate perpetrators. The state has no objection to the unsealing of the court minutes regarding the closed session in relation to alternate perpetrators. 1:25:05 p.m. to 1:36:17 p.m. This time frame is in parentheses, as you see here. Next paragraph. The state objects to the unsealing of the court minutes from the closed session starting at 1:36:17 p.m. to 2:07:44 p.m. pursuant to, and then the rule of court and the statute is given as it involves an ongoing investigative proceeding. Paragraph 3. The state has no objection to the unsealing of the court minutes from the closed session from 2:07:44 p.m. to 2:36:47 with the request that the potential witness's name at 2:35:45 be redacted. Ladies and gentlemen, if I could bring a few points to your attention. These are comments, opinions, pure speculation I bring relative to the First Amendment, United States Constitution, freedom of speech, and of the press. Number one, because the state here has raised an objection of redacting a potential witness's name, this now brings the issue of the potential unsealing of these court minutes under the realm of the court order that was issued that now gives both sides 14 days as to why any witness's name should not be revealed to the public. Secondly, relative to this matter as it involves an ongoing investigative proceeding, The public has absolutely no knowledge of what is meant here. Number one, because this hearing was under seal. Number two, there are no further details here. Is this conversely having to do with something else, another ongoing investigative proceeding, as to potentially an alternative perpetrator, or an accessory before the fact, an accessory after the fact? We don't know, because, again, everything has been sealed here. The public is completely in the dark. And if I could give a further comment here, as I do always under the First Amendment, as unfortunate and as tragic as this case is, and it is truly tragic, the idea that 4 young people were taken on November 13th, 2022, at an off-site house steps away from the campus, public university that they were attending, is tragic. However, the truth of the matter is that unalivings happen every day in this country, and sometimes they're mass unalivings. Sometimes they occur at schools. They occur even in churches. We just learned of a tragic episode that happened on August 27th in Minneapolis, Marjorie Stoneman Douglas High School. The trial of the perpetrator, who also pled guilty in that case, was not secret. It was public. Information was made public. I ask the rhetorical question, why was this case so under seal as it was, outside of the public domain, where the public was not able to observe the proceedings, like the hearing on June 18th, that was completely under seal? So I asked the rhetorical question, what was so different about this case that merited this level of secrecy that it had while it was active, and even continuing to have documentation remain under seal more than a month after this case was deemed closed, as it was on July 23rd, 2025. Since that time, not one single piece of paper from the case that was sealed from the public has ever been unsealed. As we stand today, August 28th, 2025. These are opinions that I give under the First Amendment, freedom of speech and of the press. If you have any comments, any opinions, any thoughts that you would like to share, please leave them here. Until next time, this is Kathy. Thank you for joining us here today.